My name is Ariana Cole. I am 29 years old. I sat in a courtroom on a Tuesday morning and listened to my mother tell a judge, in a calm and caring voice, that I was mentally unfit to manage my own finances. She said it the way she said most things, gently, slowly, as if the words were for my own good. The judge looked at me. The lawyer beside me looked at me. The court clerk looked at me. I looked at my hands, folded on the table in front of me, and I said nothing. Tell me where you are watching from. Drop it in the comments right now. Because what I am about to tell you is not a story about a breakdown or a hospital or a daughter who could not take care of herself. It is a story about a woman who sat in a courtroom, stayed completely quiet, and used that silence like a tool. It is a story about what happens when someone who loves you decides that love is a reason to control you, and you decide, slowly, carefully, and without any noise, that you are going to let them walk all the way to the end of that road before you show them where it leads. The courtroom was smaller than I expected. I had imagined something large and formal, with high ceilings and rows of wooden seats. Instead, it was a medium-sized room with fluorescent lighting and the faint smell of old paper. My mother, Ariana Cole, sat at the table to my left with her lawyer, a man named Warren, who had silver hair and a calm that matched hers. My lawyer, Petra, sat beside me. She had prepared me for this hearing. She had told me the claims were serious but manageable. She had told me we had options. What she had not prepared me for was how composed Diane would look. My mother wore a navy blue blazer. She had her reading glasses in her hand, which she used whenever she wanted to look thoughtful. She did not look at me when she spoke to the judge. She looked at him directly, with the expression of someone who had come to deliver difficult news they had spent a long time thinking about. She said I had been making erratic financial decisions for over a year. She said she had watched it with growing concern. She said she had tried to speak to me about it privately and had been met with resistance. Then she placed a folder on the table and slid it toward the clerk. It was thick. It had been prepared in advance. This had not happened overnight. Petra leaned close to my ear. She told me, in a whisper, that I needed to respond. She said the judge was watching, and that silence in a moment like this could be read the wrong way. I heard her. I understood exactly what she was saying. I did not move. I kept my hands folded on the table and my eyes on a fixed point just above the judge's left shoulder, and I stayed completely still. Not because I was shocked. Not because I was frozen with grief or anger or the particular kind of sadness that comes from being betrayed by someone who was supposed to protect you. I stayed quiet because in that moment, looking at the thickness of the folder Diane had placed on the table, the documents that had clearly taken weeks to gather and organize, I understood something that changed my entire plan. This was not something my mother had done in a panic or a moment of misguided concern. This had been built carefully, over time. And if I responded now, loudly and defensively, I would spend the next weeks fighting her version of events on her terms. I did not want to fight on her terms. I wanted to understand the full shape of what she had built first. And so I stayed quiet. The judge noted my silence in his book. The temporary order came through at the end of the hearing. The judge said the claims presented by Diane required further review, and that in the interest of protecting my financial well-being during the review period, he was granting partial oversight authority to my mother. She would have supervised access to 2 of my bank accounts. All withdrawals above a set amount would require her approval. The arrangement would remain in place until the next scheduled hearing, which was set for 6 weeks away. Petra wrote the details on her notepad in quick, tight handwriting. Warren shook Diane's hand. Diane thanked the judge in a soft voice and put her reading glasses away. I signed the acknowledgement form the clerk placed in front of me, clearly and neatly, the way a completely competent person signs things. The judge looked at my signature and then at me. I met his eyes for just a moment before he looked away. Outside the courtroom, the hallway smelled like floor cleaner. Petra walked beside me and said nothing for the first 30 seconds, which I respected. Then she asked me what I was thinking. I told her I was thinking clearly. She asked what that meant. I told her I would explain more at our next meeting. She looked at me the way people look when they are not sure whether to be reassured or worried. Diane was waiting for me in the lobby. She had her handbag over her arm and her reading glasses back in her hand. She smiled when she saw me, the particular smile she had been giving me my entire life, the one that sat halfway between warmth and management. She said she hoped I understood that none of this had been easy for her. She said she had thought about it for a long time before deciding to act. She said she only wanted what was best for me. She said those words, "what was best for me," in the same gentle tone she had used in the courtroom, and I noticed that the tone did not change between the two settings. It was the same whether she was speaking to a judge or to me directly. That consistency was something I had observed in Diane my whole life. Her composure did not shift based on audience. It was not a performance she switched on for formal occasions. It was her natural operating mode, which meant one of two things. Either she genuinely believed everything she was doing was right, or she was someone who had practiced this kind of calm so thoroughly that it no longer required any effort. Standing there in that lobby, I suddenly could not tell which one it was. And I realized I should have asked that question a long time ago. I met with Petra 2 days later. I told her I did not want to challenge the temporary order immediately. She set her pen down. She looked at me with the careful expression of someone who has just heard something they want to make sure they understood correctly. She asked me to repeat it. I did. She said that was an unusual strategy, and that the longer the order remained in place, the more normalized it became in the court's eyes. She said waiting carried risk. I told her I understood the risk. I told her I was not waiting out of fear or confusion. I was waiting because I needed time to see what Diane would do with the access she had been given. Petra leaned back in her chair. She asked me what I expected to find. I told her I did not know exactly. But I told her that a person who builds a case that thick, that organized, that prepared, over months, apparently, without saying a word to me, was a person who had already thought about what came after the ruling. I wanted to see what came after the ruling. Petra was quiet for a moment. Then she said she thought she understood what I was doing. She picked her pen back up. She told me to document everything and to contact her the moment anything changed. I told her I had already started. I gave Diane access to the accounts. I did not make it difficult. I did not call her constantly or ask for explanations. I let the arrangement settle into a routine, because routine was when people stopped being careful. I set up a separate personal account that was not under the order, one I had opened quietly 3 weeks before the hearing, when Petra had first told me about the claims Diane intended to make. That account was mine, untouched, and I managed it the way I managed everything, methodically and without incident. The accounts under Diane's oversight were real accounts with real money in them, but they were not my primary financial infrastructure. I had arranged that before the courtroom, when I had still believed there might be a way to resolve this without going through a full hearing. Once the order was in place, I began keeping a record of every transaction that moved through those accounts. The date, the amount, the recipient, the stated reason. I created a spreadsheet on a laptop I did not keep at home. I updated it every 2 to 3 days after checking the account activity online. I told no one what I was doing. I did not discuss it with family. I did not mention it to the few friends who knew about the case. I just watched. And I documented. And I waited to see what the numbers would tell me. The first irregularity appeared in the 3rd week. It was not large. That was the first thing I noticed about it, its smallness. A transfer of $420 had been made from the second account to a recipient I did not recognize. The memo line said household maintenance. I did not own any property requiring maintenance beyond my apartment, and my apartment's maintenance was billed directly to a separate account not under the order. I wrote it down. I did not call Diane. I did not flag it with Petra yet. I added it to my spreadsheet and highlighted it and waited. 4 days later, a second transfer appeared. $380. Same recipient account number. Different memo. This one said care coordination. I did not know what care coordination meant in the context of my life or my finances. I was not enrolled in any care program. I was not receiving any coordinated services. I was a 29-year-old woman who woke up every morning, made her own coffee, went to her own work, and managed her own affairs with complete clarity. The phrase care coordination sat in my spreadsheet highlighted in yellow, next to an account number that was not mine, connected to my money, authorized by my mother, reported to no one. The transfers continued. They came in at irregular intervals, sometimes 3 days apart, sometimes 10, which I understood was deliberate. Regular transfers at fixed intervals create visible patterns. Irregular ones are easier to describe later as one-time expenses or incidental costs. But I was not looking at them one at a time. I was looking at all of them together, accumulated in my spreadsheet, and together they formed something that was not irregular at all. It was consistent. The recipient account appeared again and again. The amounts were always below the threshold that would trigger an automatic review flag under the court order. They were small enough to look like routine account management, but they added up. By the end of week 4, the total had reached just over $2,300. None of it had been spent on me. None of it had gone toward any bill, subscription, or service connected to my name or my address. I cross-referenced every transfer against my actual monthly expenses, utilities, rent, insurance, subscriptions, and none of the transfers matched anything in my life. The money was leaving my accounts, authorized by my mother, going somewhere she had chosen. And it was being done under a court order that described her role as financial protection for my benefit. That description and that reality were not the same thing. In the 5th week, Diane filed a supplementary document with the court. It included 2 medical statements supporting her original claim about my mental fitness. Petra called me the afternoon the filing came through and read me the details. The statements described a pattern of emotional instability, impaired judgment, and difficulty processing financial information. They referenced specific incidents and time periods. They were signed by a doctor. When Petra read the name of the doctor, I asked her to repeat it. She did. I sat with that name for a moment. Dr. Frederick Osei. I knew that name. Not well, not personally. But I knew it. Dr. Osei had a private practice in the city. He was known in certain social circles my mother had been part of for years. I had met him once, briefly, at a fundraising event my mother attended regularly. I had not been his patient. I had never sat in his office. I had never been examined by him, diagnosed by him, or treated by him in any professional capacity. His name was on a medical statement describing my mental state in clinical detail. I told Petra to keep the document. I told her I needed a few days before our next conversation. And then I opened a new tab on my laptop and began researching Dr. Frederick Osei's professional record. I arranged my own psychological evaluation. I found an independent clinical psychologist, someone with no connection to my mother's social circle, no shared professional history with Dr. Osei, and no prior involvement in the case. Her name was Dr. Amelia Brandt, and she had been practicing for 19 years. I contacted her directly and explained that I needed a private evaluation, that I required full documentation of the results, and that I needed it completed before the next court hearing. She scheduled 3 sessions over 8 days. I attended all 3. I answered every question completely. I completed every assessment she placed in front of me. I did not try to perform competence. I simply demonstrated it the way I had been demonstrating it every day of my adult life, by being exactly who I was, clearly and without decoration. At the end of the 3rd session, Dr. Brandt told me her findings would be ready within 5 days. She said the evaluation had been thorough. She said she would document everything carefully. When the report arrived, I read it in full. It confirmed, in precise clinical language across 11 pages, that I showed no signs of impaired financial judgment, no instability, and no cognitive or psychological condition that would limit my ability to manage my own affairs. I printed 2 copies and gave one to Petra. I went back to Diane's submitted medical records after I received Dr. Brandt's report. I read them more carefully this time, not for content but for detail. The statements from Dr. Osei referenced specific dates on which he claimed to have observed or been informed of my behavior. I wrote those dates down in a separate column in my notebook and began checking them against my own records. My calendar. My email history. My work attendance log. The first date Dr. Osei cited was a Thursday in February, when he claimed to have received a report of an episode of financial disorientation. I had been at work that Thursday. I had a meeting at 10 in the morning, lunch with a colleague at noon, and I had submitted a project report by 3 in the afternoon. My attendance record confirmed it. The second date was a Saturday in March. Dr. Osei's statement described it as a day on which I had been observed making erratic account decisions. My bank records showed one transaction that Saturday, a grocery purchase of $61 at a store 2 blocks from my apartment. I circled both discrepancies in my notebook. Then I found 3 more. By the time I finished reviewing all the dates in Osei's statements, I had 5 entries that did not match any version of reality I could document or verify. I brought the discrepancies to Petra along with a separate folder I had put together on Dr. Osei's professional background. Petra reviewed everything quietly, turning pages without speaking. Then she referred me to a colleague of hers, a medical and legal expert named Dr. Ivan Marsh, who specialized in reviewing clinical assessments submitted in civil and family court cases. She said he had worked on cases involving disputed medical evidence and that his opinion would carry weight in a courtroom. I met with Dr. Marsh the following week. I brought Dr. Osei's statements, Dr. Brandt's independent evaluation, and my annotated notebook with the date discrepancies. Dr. Marsh spent 40 minutes reading. Then he looked up and said that the inconsistencies I had found were not minor. He said that in a clinical document submitted to a court as evidence, the kind of date and description errors I had identified were significant. He said they raised questions about whether the statements had been written from direct observation or constructed from second-hand accounts, recollections, or something else entirely. He used a specific word carefully. He said the documents, in his professional opinion, appeared to contain exaggerations. He said he was not prepared to say more than that without conducting his own formal review. I told him I needed him to conduct that review. By the time we were 2 weeks out from the next hearing, my spreadsheet had grown into something that told a clear and complete story. I printed the full transaction record, every transfer that had occurred under Diane's oversight, with dates, amounts, recipient details, and memo descriptions. Then I added a second column beside each entry, what the transfer claimed to be for, and what my actual records showed about whether that purpose was real. The gap between those 2 columns was wide and consistent. Of the total $2,300 that had moved out of my accounts during the oversight period, I could account for exactly $0 that had gone toward any service, payment, or need connected to my life. I also included a summary page at the front. It listed the total transferred, the number of transactions, the average amount per transaction, and the single recipient account that appeared in every entry. Below the summary, I had written one sentence: none of these transactions benefited the account holder. That sentence was not dramatic. It did not accuse anyone of anything directly. It simply stated what the numbers showed when you looked at all of them together, which was the way they needed to be seen. I gave the full compiled report to Petra. She read the summary page first. She did not say anything immediately. She read it a second time. Then she said we were ready. The second hearing was on a Thursday morning. I wore a gray blazer and flat shoes. I arrived 8 minutes early. Diane was already there when I walked in, seated at the left table with Warren beside her. She looked exactly as she had at the first hearing, composed, prepared, reading glasses in hand. She glanced at me when I entered and gave a small nod that managed to be both polite and slightly pitying, the kind of nod you give someone you have decided to feel sorry for. I nodded back without any expression and sat down beside Petra. Petra had arranged our documents in 3 stacks in front of her: Dr. Brandt's evaluation, Dr. Marsh's formal review, and my compiled financial transaction report. They were clean, organized, and clearly labeled. I had reviewed all of them the night before. I had slept 7 hours. I had made my own breakfast that morning and read 2 articles while I ate, because that was what my mornings looked like, and I wanted to remember clearly who I was before I walked into that room. The judge entered and the clerk called the room to order. Diane sat up slightly. Warren straightened his jacket. I folded my hands on the table. I was calm. Not performed calm. Not forced calm. The real kind, that comes from knowing exactly what you are carrying. Petra stood first. She told the court that we were introducing new evidence, an independent psychological evaluation conducted by Dr. Amelia Brandt, completed within the review period and based on direct clinical assessment of Ariana Cole across 3 sessions. She handed copies to the clerk, who passed one to the judge and one to Warren. Warren looked at the cover page and leaned toward Diane. Diane kept her eyes on the judge. The judge opened the report and read the summary section. He read it twice. Then he set it down and looked at Dr. Osei's statements, which were already part of the record. He looked between the 2 documents for a moment without speaking. Then he asked Diane's lawyer to explain the basis on which Dr. Osei had formed his clinical opinion of the petitioner. Warren stood and said that Dr. Osei was a licensed practitioner with 20 years of experience and that his statements had been submitted in good faith. The judge nodded. He said he understood that. He said his question was about the basis, the specific observations or records Dr. Osei had used to reach his conclusions. Warren said he would need to confirm the details with the doctor. The judge wrote something down. Diane's hands, folded on the table, tightened slightly. Not enough for most people to notice. I noticed. Warren requested a brief recess to consult with Diane before responding further to the judge's question about Dr. Osei's methodology. The judge granted 10 minutes. During that recess, I watched Diane from across the room. She spoke in low, urgent tones with Warren, who was writing quickly and shaking his head at certain points. She touched his arm once, which I recognized as her way of asking someone to hold their position. When the hearing resumed, Warren provided an explanation for how Dr. Osei had formed his assessment. He said the doctor had based his conclusions on reports from Diane herself, on one brief observational meeting with me at a social event approximately 8 months ago, and on records shared with him by the family. I wrote down that sentence word for word. One brief observational meeting at a social event. That was the fundraiser where I had spoken to Dr. Osei for less than 10 minutes about a book we had both apparently read. The judge asked whether the doctor had conducted any formal clinical assessment. Warren said the doctor had relied on the information available to him. The judge asked the question again, more precisely, whether Dr. Osei had administered any standardized psychological or cognitive assessment directly to the petitioner. Warren paused. Then he said no. The judge wrote something else down. His expression had not changed, but the room had. Petra stood to introduce the financial records. She laid out the transaction report methodically, the total amount transferred, the time period, the recipient account. She pointed out that every transfer had occurred below the reporting threshold established by the court order. She noted that the recipient account appeared in every transaction. She noted that none of the transfers corresponded to any verified expense in my life. She presented my records, utility bills, rent payments, subscriptions, insurance premiums, showing where my actual money had gone during the same period, paid from my personal account, without any issue or irregularity. The judge reviewed the transaction report. He looked at the summary page. He read the recipient account number and asked Warren whether the court had any information on whose account that was. Warren said he was not immediately able to speak to that. The judge turned to Diane directly and asked whether she could identify the account to which the transfers had been made. Diane said, in a measured voice, that the transfers had been made for purposes related to Ariana's care planning. The judge asked her to be more specific. She said she had engaged a care coordination service on my behalf. The judge asked for documentation of that service. Diane opened her folder. She looked through it for a moment. Then she looked up without producing anything. The judge noted that in his record as well. The shift in the room was not loud. It was not a dramatic turning point announced by raised voices or a sudden revelation. It happened slowly, the way the light changes in a room when a cloud moves away from the sun, gradually, and then all at once. The judge had come into the hearing with the framework of a case about a daughter's competence. He was now asking questions about a mother's conduct. That change in the direction of his attention changed everything. Warren made 2 more attempts to redirect the focus, once by referring back to the original petition and its supporting claims, and once by questioning the scope of my transaction report, suggesting my assessment of the transfers might be incomplete. The judge listened to both attempts. He then said that the court's concern had expanded and that he was requesting a formal review of all financial activity that had occurred under the temporary oversight order. He said the review would be conducted by a court-appointed financial officer. He said the hearing would be extended. Warren sat down. Diane sat very still beside him. She was still composed. The reading glasses were still in her hand. But something behind her composure had changed. I could see it in the set of her shoulders, which had moved inward by a small degree. She was calculating. And for the first time that morning, I did not think the calculation was coming out in her favor. Petra gave me the floor to speak. The judge had invited a statement from me directly, which was something he had not done at the first hearing. I stood. I did not look at Diane. I looked at the judge, the same way Diane had looked at him at the first hearing, and I spoke clearly and without emotion. I told him I wanted to walk through what I had observed during the oversight period, in order, beginning with the first irregularity and ending with the compiled transaction total. I explained each transfer not as an accusation but as a data point. I explained the discrepancy between the stated purpose of each transfer and my verifiable records. I explained the pattern, the below-threshold amounts, the irregular timing, the single recurring recipient. Then I said something I had rehearsed carefully, not because it was difficult to say but because I wanted to say it exactly right. I told the judge that I did not believe my mother had set out to harm me. I said that what the records showed was that she had been given access to my finances under a framework of concern, and that the access had been used in a way that served purposes other than my well-being. I said I was not asking the court to assume the worst. I was asking the court to look at the evidence and let it speak. Then I sat down. The judge looked at my statement for a long moment before he wrote. Warren began questioning Diane's management decisions in the way that lawyers do when they are trying to build a protective explanation around a client who has begun to look exposed. He asked her to describe her understanding of the court order's scope. He asked her to describe the care coordination service she had referenced. He asked her to explain how the transfers had been documented for the purposes of the court's oversight requirement. Diane answered each question carefully. She was still controlled. But control under pressure looks different from control in an open field, and I could see the difference. Her answers were slightly longer than they needed to be. She backtracked twice to add clarifying phrases. And then, when Warren asked her how she would characterize her decision-making during the oversight period, she said something that she likely did not intend to say in exactly the way she said it. She said she had made decisions she believed were appropriate because she understood Ariana's situation better than Ariana did. The judge looked up immediately. He asked her to repeat the second half of that statement. She did, more carefully this time, but the original version was already in the transcript. Better than Ariana did. Not better than the records showed. Not better than the court order specified. Better than I did. That single phrase handed the judge exactly what he had been building toward. The judge called a 15-minute recess and returned with 2 additional questions for the record. The first was directed at Warren, whether Diane's role under the temporary order had included authority to engage third-party services on my behalf without my knowledge or approval. Warren consulted his notes and said that the order had granted oversight, not independent decision-making authority for external engagements. The judge noted that. The second question was directed at both parties. He asked whether I had been consulted, informed, or made aware of any of the financial decisions made under the oversight period before they were executed. Petra said no. Warren said Diane had acted in what she believed to be my best interest. The judge said that was not the question he had asked. He asked it again. The answer, when it came from Warren on Diane's behalf, was no. I had not been consulted. I had not been informed. I had not been made aware. The judge set down his pen and addressed the court. He said the case had begun as a question about the petitioner's capacity to manage her own finances. He said the evidence now before the court had raised a separate and equally serious question, whether the oversight arrangement had been operated within its legal boundaries and in the interest of the person it was designed to protect. He said the case would not proceed without addressing both questions. Petra stood for the final time in that hearing. She placed the last document in front of the clerk, Dr. Marsh's formal review of the medical statements Diane had submitted. Dr. Marsh had completed his review 4 days before the hearing. His report was 12 pages. Petra summarized the key findings. The statements from Dr. Osei contained date references that did not align with verifiable records of my activities. The clinical language used in the statements was consistent with a prepared narrative rather than direct clinical observation. The absence of any standardized assessment methodology was documented and flagged. Dr. Marsh had concluded, in professional terms, that the statements as submitted did not meet the standard of clinical evidence required to support a legal claim of financial incapacity. He had stopped short of saying the documents were fabricated. But he had said, clearly and on record, that they were insufficient, and that the insufficiency was not a matter of minor procedural gaps. It was structural. The judge received the report. He read the summary section. He read one additional page. Then he placed it with the other documents in front of him, Dr. Brandt's evaluation, the transaction record, the date discrepancies, Dr. Marsh's review, and he looked at all of them together for a moment without speaking. That moment was the one I had been building toward since the day I sat in the first hearing and folded my hands and stayed quiet. The judge delivered his ruling before the end of the hearing. He did not reserve it for a later date. He said the evidence presented by the respondent, which was me, had sufficiently established that the original medical claims lacked the clinical foundation required to sustain a finding of financial incapacity. He said the independent evaluation by Dr. Brandt was credible, thorough, and directly contradicted the submitted statements. He said the financial records raised serious concerns about the use of the oversight arrangement that the court would address separately. He ruled that the temporary oversight order was revoked immediately. Full control of my accounts was restored to me as of that moment. He said the court would be referring the matter of the financial transactions and the submitted medical statements for further review by the appropriate authorities. He looked at Diane when he said that. Not for a long time. Just one measured glance. Then he looked at his paperwork. He said he wanted to be precise in his language. He said the court's role had been to determine competence, and it had done that. What had emerged alongside that determination was a pattern of conduct that the court could not overlook. He said the relevant bodies would receive the full case record. He said Ariana Cole should ensure she had appropriate legal representation for whatever came next. Then he closed the hearing. Diane left the courthouse ahead of me. I watched her go from the doorway of the hearing room, navy blazer, handbag over her arm, reading glasses in her hand. She walked with the same measured pace she always walked with, though I noticed she did not stop to speak to anyone in the corridor the way she usually did when she left a room. She walked straight to the elevator and disappeared behind the closing doors. Warren followed close behind her, already on his phone. Petra stood beside me and gave me the full copy of the judge's ruling, my copy, printed and signed. I held it for a moment without reading it again. I had already read every word in the room. Outside, later, Petra asked whether I was going to pursue further action against Diane beyond the referral the judge had already made. I told her I had decided not to initiate anything additional myself. I was not going to protect Diane from what was already in motion. The referral would go where it went and I would not interfere with it in either direction. But I was also not going to spend the next season of my life building a case designed to take her apart. Petra asked whether that was difficult. I thought about the question honestly. I told her it was not as difficult as it might have been, because what I needed most had already been returned to me, and the rest I was prepared to leave to the process. I walked out of the courthouse at noon. The sky was pale blue with the kind of flat winter light that makes everything look clean and quiet. I stood on the top step for a moment before going down, not for any dramatic reason. I was not staging a moment for myself. I just paused, the way you pause at the end of something long, to let the change register properly. The case was over. The accounts were mine again. The ruling was in Petra's files and in the court's record, and nothing about what had been established in that room could be quietly revised or privately reconsidered. That permanence mattered to me. I walked to my car. I sat down, put the ruling on the passenger seat, and drove to a cafe 2 blocks from my apartment. I ordered coffee and sat by the window and looked at the street for a while. My mother had walked into a courtroom believing she could define me for a judge, describe my mind, my judgment, my capacity, and have the description accepted as truth. She had prepared carefully. She had come with documents. She had been calm and credible and entirely convincing. What she had not accounted for was that I had been watching. And that watching, done quietly enough and long enough, had let her build the case that undid her. I had not needed to attack a single thing she said. I had simply documented what she did. And the truth had arrived on its own schedule, in its own language, and it had been enough.